Now I'll give the floor to Professor Warrensmeyer to talk about the right to water.
Thank you very much, Professor Vasco Pereira da Silva. I'm now in a very easy part here because a lot of issues have already been addressed by the first two speakers, so to speak, by Professor Vasco Pereira da Silva and Madame Rapporteur. So I'm probably can only add a few things, and before Professor Sansin from Ljubljana will enlighten us. I'm going to talk a little bit about the enforcement of a right to water in national legal orders. The international part you're going to listen to a little bit later. And as we recently learned, there are legal texts, international legal texts, who are guaranteeing such a right at least in the interpretation of the responsive committee in this respect, which issued the general comment number 15 and on the right to water in 2002, and as we just learned, here's also the General Assembly resolution on the right to water and sanitation, for at least pleasing some persons here. And as you have also seen, coming from Germany, it's going to be a very more laid-back kind of presentation. Cold country, cold people, kind of think in a slower way. So, what I'm trying to say is that even if you're following the approach of first, second, third generation human rights or not, the enforcement of these rights is the pivotal issue. If you have a right, that's fine. If you cannot enforce it, it's probably not so fine. And there are two ways for enforcement, of course. It's the international stage. Professor Sanson is going to talk about this. And the national one, and I'm going to tell you a little bit in this respect. And coming from Germany, I also would try to tell you a little bit about the German legal order in this respect, which is very hesitant with these rights. And also, the German courts are very hesitant in accepting these rights. And I could provide you with a different example, because for the right to water is not the utmost endangered issue in Germany at the moment. There's a lot of water, and probably we at least think that the quality is usually good. And also for the not so good of society have a kind of comparatively good access. It's, of course, different degrees in this respect. And so I also, at least, it does not matter if you divide these rights or not. I would like to make a small comment from the 1993 Vienna Declaration on Human Rights. All human rights are universal, indivisible, interdependent, and interrelated, and that's true. And also the right to life, of course, has a certain impact in this respect. At the very end of the day, if you deprive people of water, they even die much quicker of it than if you deprive them of food or something else. Yet, for the international human right, if it comes to the implementation into the national legal order, it depends basically where it is embodied. If we are following the approach of the Economic and Social Council, it is embodied in the International Covenant on Economic, Social and Cultural Rights, Article 11 and Article 12, on the adequate standard of living. So you have to have water, access to water for the adequate standard of living, and the member states to this covenant have to ratify the covenant, but this does, at the very end of the day, not really mean that people have access to this right. The implementation is still a lacking problem. You're probably aware of the two basic concepts in this respect, monism and dualism, so if it's one legal order or two, how international law is going to enter into national laws. But at the very end of the day, and this is also what the covenant is talking about, you're needing internal laws for the enforcement and for the implementation. At least it's the most preferred way, and not doing it by administrative measures or other state measures which could be possible. And in this respect, there is some debate about this international covenant on social, economic and cultural rights concerning the enforcement. And because one of the general provisions of this right, of this covenant, Article 2, paragraph 1 only speaks of the progressive realization. So if you have a right entailed in the covenant, it's unlike in the other covenants, the sister one, which is certainly full rights, individual full rights. It's the first generation. I will never repeat this frame again. It's only realized in a progressive way, whatever this means, but it only means, more or less, that the state has to do steps in the proper direction. And the steps are up to the state at the very end of the day. And so, but also, the committee said, and it has also been mentioned earlier, that some minimum rights are enforceable. So some basic standards are certainly enforceable. And so a total deprivation of the right to water would certainly be an enforceable right. And probably also, if it comes to sanitation or so, it's going to be very difficult at the very end of the day if the state is not doing anything in this respect. But then the second issue is, and I mentioned it in this respect as well, what does effective implementation really mean? And generally speaking, it should mean that the means used should produce results which are consistent with the full discharge of the state's obligation. But at the very end of the day, that's still in the discretion of the states. And so a state is still the actor in this respect. So the national state, it's the hand of this national state to realize the right. Yet, under public international law, which then also would have a certain impact on the national laws, the Vienna Convention on the Law of Treaty requires, Article 27, the modification of national legal orders to give full effect to the provisions of a treaty. So, even it can be argued, and I would argue, that the state has to enact a law and has to modify its national legal order for the full implementation of these rights. It sounds rather general, but it is very important, because only then, if it is a right, we then can discuss if it's an objective or individual right, but at the very end of the day, only if it's a right, someone can have the chance to challenge it in a court. The other thing is, it's also in discussion in this respect, is can these rights be self-executing? So if you're talking about second generation rights, can they be self-executing? So can they have a legal effect, a direct legal effect in the national legal orders? This is extremely debated, yet the view that I'm going to share now with you is that these human rights instruments are really living instruments. These are instruments which we shouldn't seen in the way that has been drafted in the 1960s. These are living instruments with a new impact, which have gained more and more legal standard over the time. And so, from a theoretical point of view, it is not excluded. It can have the effect of a self-executing right. And in this respect, it depends again on the national legal order. And for Germany, of course, we would be very hesitant in accepting it, but at the very end of the day, it can be that it has to have this kind of effect. Especially if it's not adequate access to water resources. And you know, if it's really inadequate, if it's a clear breach of the convention, then someone should argue, or could argue this in this respect. German courts, now providing you another example in this respect, are very hesitant in accepting the rights of the second covenant in their national legal regime. And this is also due to Article 2, which I already mentioned, this progressive realization, and the other thing is the provision on limitations, Article 4. The rights in the convention can be limited by national laws if these laws are in compliance with the nature of the rights embodied in the covenant, and these laws do promote the general welfare of a democratic society. So the problem is, what is the nature of these rights? So there is some leeway for the states, and a lot of lawyers are arguing there's a lot of leeway in this respect. And what is the promotion of the general welfare in a democratic society? Rather general terms, to say the very least. And my legal answer to these issues would be, as a limitation of the rights embodied in the covenant, Article 4 has to be interpreted not broadly but strictly. It's a limitation to these rights. And so, even it should not be, or the laws limiting the enshrined rights shall not be seen in a too broad way. They have to really target some issues, and they really have to be in compliance with the nature of the SCR rights. And this nature here is to provide with an adequate standard of living. They cannot go below this. And this adequate standard of living means that you have access to safe water and sanitation. But safe drinking water, safe sanitation, this is what you're needing. There's no other way around this in this respect. Yet, as I told you earlier, German courts are very hesitant in this respect. And some other national courts as well. And another way, besides creating a new law and to have a proper enforcement of these rights, is that you can interpret existing rights in light of the international norm, because it's part of your national legal order at the moment you're ratifying it. And that's, for instance, is a way that some German courts are very keen on, but some others are not, but that's usually the way how they're applying it. And in some other jurisdictions this is done as well, because it's a much easier way for implementing and for effective implementation of a certain rule. On the other hand, there are limits to interpretation, and you cannot go further, at least in Germany, as the wording of the provision is saying, and then it sometimes creates problems in this respect. And these limits of interpretation have also to be kept in mind, so it's probably not the most preferred way which should be given to any way of implementation of these human rights. Finally, in this presentation, I would like to talk a little bit about regressive measures or retroactive measures, which is for the for the right to water important, but for all social rights very important. Can a state go back to, after he has implemented the full right, can it go back to a status before this? And the legal answer is very complicated in this respect, extremely complicated. I would provide you with an example which doesn't have to do anything with water law, but is rather telling. In Germany, we had an abolition of tuition fees at universities, Article 13 of the same covenant. And then they had been reinstituted a couple of years ago. And then the legal issue was, it came up in front of the courts. No one of the German judges has ever had a look at this nice little covenant. The issue was, is this a violation of the covenant because it's a retroactive measure. It's a regressive measure. You know, we had tuition fees in the 60s, we ratified the convention, we abolished them, and then, of course, they were there again. So if you have good water quality, can you just go back from this kind of standard, for our example here? The German courts actually did not see a problem in this respect. They thought they can go back because the covenant does not grant a prohibition against a retroactive measure. In my humble opinion, it's not absolutely correct. In my humble opinion, the covenant does speak out against retroactive measures because it's just because it speaks of the full realization of the right and means that if you have attained this status, it would be against the nature of this right, the telos, to go back and to insert any retroactive measures. The wording of the covenant is not really addressing this, yet I do think you can make a very good argument in this respect that it's prohibited. I was, unfortunately, a huge minority in my country in this respect, but
you have our support.
yeah, yeah, it did neither help the students nor anyone else, but because they had to pay the tuition fees. But I can tell you, well, for making at least this story short, for cutting it off, that now every German state has abolished the tuition fees again. After 6 years or so of reinvention, they got rid of them again. And because there was a huge public debate on if someone should pay for public education. But that's another issue. But here for water rights, it's a similar one. And you can see the analogy. You can see the analogy also for sanitation. You can see the analogy. It's a clear-cut case. And to my opinion, to put also a legal argument in it, Article 2.1, which is then the main argument here, is not prohibiting it because a retroactive measure after full harmonization is an aliud to any progressive measure. And so you cannot reactively put this into light. So what I wanted to tell you here is that if it comes to these rights, it's very difficult to have an effective implementation sometimes from a legal point of view, but that's a covenant seen as a legal document is providing much more amplitude and possibilities, and I usually argued in this respect, and that for a proper and effective national implementation of these rights, it's more than necessary to have laws, and then that these rights and laws are also effectively in front of a court so that they give rise to a kind of individual rights. And we're not talking about objective rights. We're talking about individual rights that can be enforced in front of a national court, so that this distinction between first, second generation human rights can really be blurred. And that we're talking about human rights, but this is not always a preeminent view on the planet, to say the very least, in this respect. Thank you very much for your attention.
And we learn a lot from you, and we've seen that even in German there are progressive persons, and and that's very important for nowadays. So, to finish, and last but not least, we are going to assist to a miracle, since now someone is appearing from the internet. She's in Ljubljana. Professor Vasilika Sanchin. It's a pleasure to have, an honor to have you here. You have the floor.
So good afternoon, panelists, ladies and gentlemen. It's my great pleasure to be able to participate in a panel with such renowned experts on the topic of the human right to water. And my heartfelt thanks go to the organizers, and in particular to Professor Rui Guerra da Fonseca for making it possible to use this modern technology to enable me to speak to you. Can you hear me?
Perhaps we have some technical problem. Could you try to adjust? Because it's difficult to understand. We hear you, but it's difficult to understand the words you're saying. Just a moment. We are going to try to solve it. Oh, it seems that we can see you if we are downstairs. So perhaps we should move and try to hear you better. Because here, there's a kind of an echo that avoids us to hear you. But
Okay. Okay, I'll try, and then you let me know if it works. Okay, so once again, I'd like to thank the organizers for inviting me and Professor Rui Guerra da Fonseca for making it possible for me to participate from Ljubljana, from Slovenia. And all the distinguished panelists who were speaking before me have already addressed many fundamental issues connected with the human right to water. And thus, in my presentation, I would like to briefly present some remarks on international mechanisms for realizing this right. Now, although I'm talking to you from a distance and even from a different time zone, and not even using a PowerPoint presentation, I nevertheless hope that my intervention won't be neither powerless nor pointless. In the interest of time, seeing that we are running a bit behind the schedule, I'll try to be brief. So the normative framework for the right to water, as we already heard, consists of a number of treaties adopted at universal and regional levels, as well as various decisions taken by various organs of international organizations, including the seminal General Assembly Resolution 64 through 292 in 2010, and the subsequent Human Rights Council and General Assembly resolutions. So before going more concretely into specific international mechanisms, allow me to make two general observations. The first one is that all human rights, as we already also heard today, impose three types of obligations on governments. That is the obligation to protect, the obligation to protect, and the obligation to fulfill human rights. Now, the purpose, in my opinion, of establishing and using international mechanisms is to assist states who have the primary responsibility to protect, respect, and fulfill the right to water. Thus, they complement and not replace the responsibility of states. That means that ratification of relevant treaties connected to ensuring the right to water does not excuse states from adopting national water plans and strategies, domestic legislation, and to provide access to court for individuals. Because one of the basic tenets of state responsibility is to ensure human rights of individuals on their territories. Thus, for me, it is very important to keep in mind that these international mechanisms should be viewed as complementary to states' endeavors rather to replacing or filling the gaps where the states are not active to ensure human rights. My second observation goes to various possible categorizations of international mechanisms according to different criteria. Thus, we can speak about international mechanisms on universal level or the regional level. Logically, the raison d'etre of regional mechanisms is to add something to universal ones, and thus it is also logically to observe that regional mechanisms also in the field of ensuring the right to water have so far provided more concrete results than the universal ones. Now, the other possible criteria for categorizing the international mechanisms is according to the organs that are active in them and the effects of their decisions. Thus, we could divide these mechanisms into political or policy ones and to the legal category, where we would find treaty-based bodies or even judicial bodies dealing with human rights, including the right to water. Their decisions can be of recommendatory nature, or they can have a binding force if we are talking about judgments adopted by relevant courts. Another possible category, that's the third one, could be dependent on the sector or we would like to discuss the human rights to water in. So we could speak about the field of human rights, we could speak about the field of environmental issues, as was the topic of the first speakers today, development, health, trade and investment, finance, labor, social field, and even the loss of armed conflicts. So the final category I would like to stress in this presentation is whether we are talking about international mechanisms that are active in regular or let's say normal circumstances, or those that become active in times of emergencies, or the division between the mechanisms that are being used in times of peace or in times of armed conflicts. So as we see, there are various possible categorizations, and of course it would be impossible to address all of them. I would just like to briefly mention a couple. In the category of, let's say, universal mechanisms, probably it is logical to first mention the United Nations and its various organs dealing also with human rights issues. Of course, as was already emphasized a couple of times, it was this 2010 seminal resolution of the General Assembly that for the first time clearly pronounced the right to water and sanitation. And in the opinion of the General Assembly, of the Secretary General Ban Ki-moon, this meant that this now, together with all the already existing normative framework, provides a very solid legal framework for governments and the United Nations system alike to actually materialize the two enshrined rights. And at this point, I would like to agree with the Special Rapporteur, Kristin Albuquerque, that basically it would be better to talk about two rights that are enshrined in the right to adequate standard of living. So it's not one right, but it is two rights, right to clean water and the right to sanitation. Then, of course, the mechanisms that exist within other body United Nations. For example, Human Rights Council was mentioned a couple of times today. And one of the achievements in the field of the right to water undoubtedly is the establishment of this position, first of the independent expert and then the special rapporteur on the right to water. And it's great to have the pleasure of company of the person taking this position. So, and let's not forget that also in recent years, the Security Council has established a series of, has adopted a series of resolutions that call for adequate protection of civilians in times of armed conflicts, including women and children. And the right to water is one of the important rights that they should be ensured even in times of armed conflicts. So even the Security Council, not directly but indirectly, has a capacity, has a competence to deal with this issue. There is an important role of the Secretary General to bring to the attention of the other organs whether there are situations where people not having the access to clean water might suffer from undignified life or undignified human conditions. So, in addition to these, let's say, more political organs, we also have a set of treaty bodies that were established on the basis of the relevant conventions adopted in the framework of the United Nations. And here, already mentioned today, is, of course, the probably most relevant International Covenant on Economic, Social, and Cultural Rights, but also International Covenant on Civil and Political Rights. Although these two covenants, together with the Universal Declaration of Human Rights, form the very well-known Bill of Rights, they are not the only treaties relevant for actually realizing the right to water. There are also other conventions, International Convention for the Elimination of all forms of racial discrimination, discrimination against women, rights of child, persons with disabilities, and so on. So all these treaties have established bodies which monitor their implementation, but also, based on the optional protocols of these treaties, have established procedures which allow for individuals to file individual complaints if their rights are not respected. And here, I would like to stress that for many years, the Committee for Economic, Social, and Cultural Rights were not able to receive individual complaints because no such optional protocol was adopted until 2008. And more importantly, this optional protocol that allows for individual complaints entered into force last year, in May last year, and now provides an opportunity for individuals to submit their individual complaints to this committee. In addition to this procedure, the optional protocol envisages also the interstate communications and inquiry procedures. And to date, already 3 states have accepted this competence of the committee to address this kind of submissions or start of procedures, including Finland and Portugal, in addition to El Salvador. So I see this as a very important development in ensuring individuals' possibility to access this international mechanism to address possible violations of the rights enshrined, especially in Articles 11 and 12 of the International Covenant on Economic, Social, and Cultural Rights. But there are also other mechanisms, let's say outside the United Nations, strictly speaking, as an organization, existing within various of specialized agencies, programs, and funds of the United Nations. Thus, we could also seek redress or seek assistance from various mechanisms within the World Health Organization, Food and Agriculture Organization, UNICEF, UNEP, UN Habitat, International Labour Organization, United Nations Development Programme, and so on. But also, this right to water has significance in the work of the financial institutions, as the International Monetary Fund or World Bank Group, which should take into account this right in deciding on their lending policies, credit arrangements, structural adjustment programs, and other development projects. Importantly, the WTO, the organization competent to deal with trade issues, has also been cognizant of this development right to water, but probably even more important, there is already an existent practice where the right to water has been addressed in the arbitral proceedings established on the basis of the International Center for Investment Disputes Convention, where actually the tribunal decided that the right to water should be properly taken into account also in the investment agreements and the obligations of states deriving from them. In addition to these, let's say, universal mechanisms, there are a number of regional mechanisms that of relevance, also established on the basis of regional treaties that were adopted in the field of human rights, such as the African Charter on Human and People's Rights, African Charter on the Rights and Welfare of Child, the European, of course, Convention on Human Rights, the Inter-American Convention on Human Rights, and so on. And what is probably more important is that these bodies that were established on the basis of these regional treaties are judicial bodies and already have certain jurisprudence relevant for realization of the right to water. Just to name a few examples, for example, African Commission on Human and People's Rights dealt with cases concerning also the right to water in 2009, the Zaire case, the Center of Housing Rights and Evictions versus Sudan case. Then the Inter-American Court of Human Rights dealt with, in 2010, with Kmok versus Paraguay case, where they found the violation of the prohibition of cruel and inhumane treatment in prison because of also the lack of access to clean drinking water. But as we are all living in Europe, it is very important that we also consider the jurisprudence of the European Court of Human Rights. And here we have cases from 2006, Melnik versus Ukraine, Fedotov versus Russia, all finding violations of Article 3. But since I hope we will never be in a situation of imprisonment or detention, I think the really relevant case also for realizing the right to water is the judgment from 2011 in Dobetska and others versus Ukraine, where the court found the violation of Article 8, so violation of right to family life, because the claimants managed to prove that they have deteriorated the government has deteriorated their health on account of water pollution by toxic substances in excess of permissible concentration, which worsened the quality of their life, and they didn't have access to clean drinking water because the water was contaminated. And the plaintiffs were awarded also non-pecuniary damages for that. So this judicial development, I think, is extremely important for the individuals who, of course, attain the adequate standard of protection of their basic human rights. Now, all these international mechanisms, be it on universal or regional level, presuppose the exhaustion of local remedies, meaning that the individuals must first exhaust the available local remedies unless they are not available or be reasonable to expect that they will get any satisfaction by referring to these domestic mechanisms. Now, let me say that based on these existing mechanisms, we can say that progressive realization of this, as it was referred to, second category of human rights to state level as well as to the international level. And it seems that universal mechanisms to enforce the right to water are still lagging behind the regional ones. However, this is nothing new nor surprising. It was the case also with other human rights. If we just consider the well-established jurisprudence of the European Court of Human Rights from 1950s onwards, and the lack of the Universal Human Rights Court dealing with the same issues. But I see the entry into force of the optional protocol to the International Covenant on Economic, Social, and Cultural Rights a step in the right direction that offers a forum for individuals individuals to bring their complaints if their right to water or sanitation is not respected. For the time being, at the political level, we have the Human Rights Council being active also in this area, and at the time being, it is a subsidiary organ to the General Assembly. However, we know that at times of the creation of this council, there were also ideas presented by the Secretary General to establish a third Human Rights Council equal to the Security Council and the Economic Social Council as the main organ of the United Nations. So there is also room for improvement also in the area of political organs. Now, as to the judicial organ at the universal level, I would like to note that the water issues are not unknown to the World Court. The ICJ dealt with water matters in, for example, the Gachikona-Gimaras project case or the pulp mills case. However, it is true that it was dealing with these issues in a different manner. It wasn't addressing the right to water. However, it is not impossible to imagine that in the future, a state might bring a case before the court on the basis of diplomatic protection of its nationals who were denied their right to water in another state. So, potentially, even this judicial fora could be used for the realization of water. Last but not least, I would like to mention that I see as a very important development in the realization of the right to water that the human rights obligations are no longer only the domain of states, but are moving also outside non-state actors, in particular multinational enterprises. And in this respect, I think that the seminal work was done by the OECD and the General Assembly adopting the guidelines on the respect of human rights by companies, multinational enterprises. And this offers, I think, the additional layer of protection of also the right to water in all trade or investment disputes. To conclude, all these mechanisms that provide redress for possible violations of the right to water lack efficient enforcement mechanisms, as it was already stated a couple of times by my speakers before me. And however, this is not a problem unique to the realization of the right to water. And this is where the efforts of states to comply with general observations or concrete recommendations or judgments of judicial bodies is essential. The states are the ones who are the first responsible for the realization of the right to water, and at the end are the ones who will have to comply with the decisions of the bodies adopted under various international mechanisms. Thank you very much for your attention.
Thank you very much for your interesting lecture. It was like if you were here between us. We could understand you perfectly, and we enjoyed very much having you in Lisbon. We have a touch of Ljubljana, a taste of Ljubljana, let us say, here at the Law Faculty of the University of Lisbon. So now the lectures are concluded, it's time for an open debate. Anyone in the audience who want to put any question to one of the interventors, even to Professor Vasil Kasanchin, that can hear us and is also with us in this room. Don't accept no more first answers, first questions, just the seconds. Please go ahead. The seconds are easier. The first are always complicated. Please.
I come from Mersar, my question is regarding the presentation of Mrs. Catarina. We have done recently a conference where you participated, and one of the main conclusions that we came up was that there was no register of minorities in Portugal. And there was no differences or differentiation between different groups and different groups in the society. And this is mostly seen as a problem in terms of differentiating people and creating segregation of groups. So how does this cope with your intervention in terms of differentiating the levels of access to water and sanitation in different groups?
Very much. More questions? Perhaps you could join 2 or 3. Please here in. Okay. First.
I have. Is it possible to listen? Yeah. I have a specific question to Professor Lindmeier that that concerns the prohibition of regressive measures by the states. For what I know, this principle of prohibition was created by the German doctrine. And it was created because in Germany there are no social rights in the constitution, at least in an express way. I think it is clear today that this is only a principle, it's not a rule, and therefore there's not a total prohibition to go back. But it is a bit weird to hear that in a case like this, the court didn't use this principle in I don't know. It didn't require at least some justification to go back. And my question is, I wanted to know a little bit more about the fundamentation of the court in this case.
Thank you. Here in the first row.
Jaime Batista from Portuguese Regulator of Water and Sanitation. First of all, congratulations for this initiative from the university. Catarina, thanks for all the work you are doing in this field, and I have a question for you. Based on your experience visiting so many countries around the world regarding this topic, my feeling is that this kind of problem in many countries must be solved not with specific measures, legal measures, or with some money from this or that origin, but with real, sound public policies, which is a responsibility of the government. And that means a lot of things, not only legal issues, not only financial issues, but a huge number of different areas must be part of that public policy. It's probably not true in Portugal or Germany or whatever, because we have those policies, and in those countries we need, those developed countries, we need probably to improve some legal measures here or there to solve the residual problems we still have. But in most of the world, it's not like that. It's necessary much more public policies, and that is quite different thing. I would like to have your comments about that.
Thank you very much. Any other question? Here.
Good morning to everyone. Congratulations to all the panelists on these presentations. My name is Luís Simas from ERSAR. I'd like to ask a question about the reducing of inequalities on safe access to safe water and sanitation. Of course, I fully agree with Ms. Catarina Albuquerque relating to the role that the state has to reduce these inequalities. But one of the things that is also an aspect important of this problem is how to bring those minorities to the system. Because sometimes the countries are well organized, there is a system to provide safe water and sanitation, and sometimes you have to bring the persons within the system. And it's important also to tackle this difficulty, because the state provides the safe access to water and sanitation, and the difficulty lays on bringing people within the system and how the system is organized.
Much. Any other question? So we can finish now this round. Afterwards, there will be another round if you are also interested. And I'll give the floor first to Mrs. Catarina Albuquerque.
Thank you very much. I also want to answer the question that was not directed to me. Do you allow me? No, it does not mean that you have to answer it. You have no choice.
I had no answer. I would like to say something too.
I'm joking. Okay. Regarding the first question you asked, this is a problem. And when I was on mission in Slovenia, and when I criticized the government because, and I was saying that they were excluding the Roma minority, we had the same type of discussion. Because the government said, because of the protection of these minorities, we cannot disaggregate data to single them out, because this would further stigmatize them, etc. In Portugal, we say the same, that it's against the constitution to do it, and Portugal has been the focus of recommendations by several human rights bodies of the UN. My colleagues from, it's the working group on discrimination against Afro-descendants, also recommended Portugal to disaggregate the data. The Human Rights Council in the UPR, the Universal Periodic Review, has recommended Portugal to disaggregate the data, and we have not been doing it. And we have, our official position is that it's against the Constitution. I don't think it's against the Constitution, because you are not singling out one person. It's not Mr. Zemanel who we are singling out. We are singling out a group of people who might be Roma, a group of people who might be living in rural areas, a group of people who might be whatever. So I don't think it's incompatible, because you are not revealing the names unless you are talking about a group that is so small that there are only two people, and then you would be identifying them, and that could be a problem. But here I don't think, and I know that the Portuguese government is working on these recommendations, and the National Human Rights Commission is working on these issues. On the prohibition of retrogression, I will not, of course, answer on behalf of what is going on in Germany, but I will talk a little bit about the Committee on Economic, Social and Cultural Rights, and I will also make a little bit of advertisement. My last report to the Human Rights Council was on this issue, precisely, retrogression. It was on two things: sustainability, because sustainability means you have to make sure that the progress made is sustained, and then the flip side of sustainability, retrogression. And it's available on the internet for free. And what the Committee on Economic, Social and Cultural Rights has said, it's a little bit more conservative as what you have said. What the committee has said is that, in principle, any retrogression is prohibited. And it's a violation of the covenant, because the vision of the covenant is in this direction, not in this direction, right? Okay, that's number one. But then the committee has said that cases of retrogression, backward steps, might be justified in certain circumstances, as, for example, in cases of an economic financial crisis. But then it has also said that the burden of proof is on the side of the government. In principle, it is a violation, and it is the government that has to prove that it was not a violation. And of course, and then you have to look not only at that right, you have to look at the totality of the right, and then you have to look at how the budget is being allocated. What are the priorities by the government? Is the government disinvesting in the area of human rights and investing more in debt relief, for example, or in other areas? And there you might reach the conclusion that you have a violation of human rights. I'll also make a little bit of advertising. I wrote an article for Expresso, which will be published tomorrow, where I mentioned this issue. Because of water, because there have been use of water cuts in Lisbon, and, and in other parts of the country. And what I say is that, in principle, these are violations of human rights. And now the burden of proof is on the side of the government to show, no, we used due diligence, we knew who we were cutting, the reasons for cutting were not, or the reasons for non-payment were not for reasons beyond people's control, etc. And it's up to the government to prove that these were not violations. Regarding our regulator's question, yes, I fully agree with you that we need a package, and the laws are important. We should not be saying this in this faculty because it might be a sin. The laws are important, but they are just the beginning of the story. You need the laws, and many people, I think in the water sector, but also in other sectors, say it's not that important to have the law. If you have good policies, that's enough. I don't think so. I think that it's fundamental to have a law, also for the reasons that the other speakers have mentioned, also for questions of justiciability, access to justice, and empowering and empowerment of people. Because a policy exists today, it might be revoked tomorrow, and the policy in itself doesn't empower you, does not give you the right to hold your government accountable before, or not necessarily before a court of law. It does not give you directly a right. But I agree with you that the cases where and what you need is public policies. I fully agree with you, and especially, and I always think of two countries that I visited at the other end of the world, countries I did not even know that existed, Tuvalu and Kiribati, where, well, yes, they need everything, from the law to the policy to the budget. They don't have anything. But in the majority of the countries, you have very often the laws, and then you don't have the policies, and of course then the implementation is not possible. So yes, I agree with you. I think I always agree with you. Thank you. Sorry, desculpe, lá é que estava no outro lado da página. How do we bring the minorities to the system? When I don't talk about reduction of inequalities, I talk about elimination of inequalities. And of course that's a problem, and there is no clear-cut answer. That's yes, and that's why we need laws that set out the principles and say we have to eliminate inequalities. But then you need the policies and intelligent policies that will manage to address these more difficult issues. And I'm not saying that it is easy. It's something easy to address. But for example, I visited countries like Jordan or Egypt, where you have problems with the Bedouins, which are nomadic people, how do you bring water to them? How do you bring them the services? And these countries decided, okay, we will provide them with water through tankers, water tankers. And even though for the Millennium Development Goals this is not acceptable, for me, I think that in human rights terms it's acceptable, because these are nomadic people. If the water is of quality, if it is affordable, it's even given out for free. For me, that's okay. For example, in informal settlements, slums, favelas, etc. How do you do it? It's illegal to provide the water. The people don't own the land, or they are not renting. They are there illegally, between inverted commas. What do you do? And in many countries I've been to, the government tells me, we cannot, because they are illegal, we cannot, and it was the case in Egypt, in Bangladesh, etc. But for example, you go to Brazil, some people tell you the same, but in other parts of the country, they have come up with provisional systems, where you provide, they are made of plastic pipes, just to provide thin plastic pipes that are provisional until the courts decide the fate of these people. Shall we legalize this settlement or not? Do we have to remove the people to another place? Whatever. But in the meanwhile, and this is what I was saying, people cannot be deprived of the right to water. So, well, one solution can be these small plastic pipes that provide water to the people, or the tankers, or whatever. I think that then it's up to the governments, national governments, municipal governments, to come up with most adequate solutions that are also affordable. And you have to take into account, of course, the context of the said country. What is important to say is that human rights don't have a one-size-fits-all solution for every country in the world. They set the goal, and then there are different ways to reach the goal. And I will make the last advertisement, the last commercial break, and you know about what I'm going to say. I published 2 years ago, with the support of ERSAR, a compilation, and of course, and also the German government, and the Spanish government, etc. A compilation of good practices in realizing the rights to water and sanitation. It's also available on my website. And I think what this compilation shows, it's just a tiny number of examples, but it shows the different ways in which you can implement human rights, and also reduce inequalities, and also reach the most hard to reach people. I hope I answered to your question. Thank you.
Professor Orensmeyer.
Just for adding, we're probably pretty close when it comes to our opinion in this respect. I mean, the object and the purpose of the covenant is probably rather clear in this respect, that these retroactive measures are a problem and probably not in line with it. And of course, there can be emergency cases, and then the issue is how to deal with them. Yet, at least I would argue that, again, they have to be interpreted in a very restrictive manner. So, well, at the very end of the day, of course, you have to find a solution for certain problems. Coming back to the German issue, which you probably were asking too, and I'm unable to provide you with an objective opinion in this respect, because my opinion has been cited in every court case in this respect, and almost all of them have been lost, sometimes with hilarious argumentations, but that's a different issue. And if it comes to the education issue, even the special rapporteur for education of the UN was criticizing Germany very much in this respect. And to put it from a more legal answer, yes, constitutional-wise, these any kind of collective or second-generation rights are seen with great hesitation by the German Constitutional Court, because the German Constitution is focusing on individual rights. Secondly, from a legal point of view, for instance, the rights of the covenants are only in part of, when it comes to legal hierarchy, they have the status of a federal law, but not of the constitution. And there where the real enforcement problems are going to start. At the very end of the day. And then for the education measure, there's another nice little sub-problem. Germany is a federal state, and education is the exclusive competence of the sub-states. And so how far an international treaty concluded by the federal state can interfere in the rights of the sub-states. But that was a nice little sub-issue in this respect. It wouldn't, to a certain extent, the same as water, by the way, but that's also but that's a different issue. And the courts were very hesitant in accepting that this covenant is an enforceable individual right. It's part of the objective legal order, yes, but can you really base as an individual your claim on it? And if it's part then of the legal order, how is it in line with certain other rights, especially some constitutional rights? Yeah. Budget of the state, and so on, and so on, and so on. Which was basically the issue, state budget versus an individual right of free education, or individual right to sanitation and water, whatever you'd like to put. And this had to be balanced to a certain degree, and the courts were very hesitant in saying that the covenant is justiciable. It's an enforceable human right, and which is a real problem then in this respect. Some courts did, some very important courts did not. The German Federal Administrative Court, who was the last court in this respect, tried to find a different solution and tried to find a solution over the constitutional right to education or to get a profession, which is then part of education. But it's a very tricky issue, I think.
Just two short points, even if I was not asked. One about the principle of equality, the second about retroaction, which were the things that interest me more. About the principle of equality, we have to keep in mind that today we have a positive approach to that principle. And that means that if we don't discriminate, we should know exactly about the persons and who are the persons. So that's no discrimination. And I recall a case that happened in Germany, but also happened in France and also happened in the United States about freedom of religion. And the question was, when the school asked to a certain students what was the religion they professed. And the first reaction was, this is against equality. But in the end, if there is a reason for that question, and the reason was to furnish the food for the children when they are at the school, that is justified. So when we are talking about this problem of the water, the situation should be put in the same way. We cannot qualify the situation in discriminatory ways, but we can differentiate. So yes, we can have data. Yes, we need to know which are the groups involved, but we should not discriminate. And the reason for that knowledge is not discrimination, so it must be accepted. The second, about retroaction. I must say also that I don't like very much the idea of a prohibition of retroaction, because I don't see the law as a progression against something that will be the end of history. That's not my way of view. So the idea of prohibition of retroaction is not, from my point of view, the best way to put the problem. But in another hand, there are other solutions. If we think there are limits came from human dignity that reach the same result. So if we don't think about retroaction, but if we look at that retroaction, like an aggression to human rights, that can be prohibited. So it is something that can reach the same results, but with a different approach. So in my view, the idea of a prohibition of retroaction is too much from the constitutional point of view, but the idea that the retrospection can be a serious threat to the human rights and to the human dignity, it's another way to reach the same solution and probably more effective. Well, I don't know if Professor Vasilika Sanchin wants to say something, also from Ljubljana, about our discussion here. No. I don't know if there is any other question from the audience. If not, let me thank you again for being here. Thank again all the participants. It has been a wonderful meeting. We need to have more this in this faculty. By the way, and to answer Mrs. Albuquerque, the faculty is very different. We are very open. 20 years ago or 30 years when I got my PhD, it was impossible to have a discussion like this in English at the law faculty. Now we are having lots of English events, and we are much more open, and we can talk about everything. And that's the good thing about a university, a living university like we are. Thank you very much. It was a pleasure having you here.